Hear ye, hear ye, hear ye. The Court of Appeals for the 14th Texas is in session. Pursuant to adjournment, God save the Constitution and His honorable court.
Welcome to the 14th Court of Appeals. I'm Chief Justice Kim Frost. With me today is Justice Kevin Jewell and Justice Charles Spain. Together we will hear the one case on this afternoon's docket, Meta Planning and Design versus BGE Inc. Let me go ahead and say, in the event we experience technical difficulties, freeze frames, or anything to do with our electronic platform, please just stay tuned and until we're able to reconnect. And if it's necessary, we'll allot additional time for more argument. Each side will have 15 minutes to present argument. If the appellant wishes to reserve time for rebuttal, let us know, and we will set the clock accordingly. We have read your briefs and we are eager to hear your arguments. We'll begin with the appellant now.
Thank you. My name is Whitney Brick, and I'll be arguing today on behalf of the appellants. We have reserved 5 minutes for rebuttal, so I appreciate that. May it please the court. The public policy of Texas is that every contract and restraint of trade and commerce is unlawful. That's because Texas favors competition and seeks to pass down its benefits to the consumers across the state. Of course, a limited exception to this policy is an enforceable non-compete, but it's undisputed that BGE did not have a non-compete for 6 employees who departed in 2018 to form a competing startup. That startup was Meta Planning and Design. And when Meta started realizing some success a few months later, BGE did by lawsuit what it had not done by contract, and it filed an unverified ex parte application for temporary restraining order and claims based on pretextual allegations of trade secret misappropriation. Not unsupported legal action improperly sought to stifle, intimidate, and silence free speech and association of its competition, Meta and these former employees. And that's exactly what the TCPA was designed to protect against. So the trial court's order in this case should be reversed and the claims under it dismissed for 2 reasons. First, the TCPA applies, and second, because BGE failed to meet its burden to either establish an exception or to establish with clear and specific evidence a prima facie case of each essential element of each challenge cause of action against each of these 7 defendants. I'm turning first to the first step of the 2-part analysis under the statute, whether the TCPA applies in the first place. I want to note that for 2 claims, trade secret misappropriation and tortious interference, BGE has conceded on appeal that those are covered by the statute, so I think we can set those aside for today's argument. But with respect to the claim for breach of fiduciary duty, BGE argues that that claim cannot meet the definition for either right of association or right of free speech, the protected conduct under the statute, because both require a communication. And according to BGE, that claim is not predicated on any communication. And we think that's wrong for a couple of reasons. The first is that if you look at BGE's own pleadings, they reflect that that claim is in fact based on communications. We describe the allegations on pages 15 and 16 of our brief, as well as on pages 21 to 24. But I can tell you what they are. BGE says that there was a prohibition for these employees while they were with BGE not to, quote, discuss or, quote, disclose certain financial, sensitive, confidential matters. They were also not to, quote, share any product information or specific marketing strategies. And of course, they were not to use or, quote, disclose any or misappropriate or use for the benefit of Meta any trade secret information. And all of those words, discuss, disclose, share, that's what BGE alleges the individual defendants violated, and they gave rise to the claim for breach of fiduciary duty. Now, there's no authority that they've cited in their brief for the proposition that a breach of fiduciary duty claim can't be based or can't involve communications that would satisfy the statute. And in fact, we know the opposite is true because we've got the Abaticola case that said that such communications can be part of a trade secret communication giving rise to that kind of claim. And in the Reeves versus Harbor American Central case, which came out more recently, that's not identified in our briefing because it came out after briefing was closed. And the Southwest side is pending, but that's docket number 14-18-00 594. That case did involve a very similar case of breach of fiduciary duty that was based on an allegation of trade secret misappropriation. A former employee departed, joined up with another colleague to form a competitive business. And this court said, based on Nevada COLA, the allegation that supported the claim for breach of fiduciary duty based on the alleged taking of confidential information to compete did satisfy the statutory definition for at least right of association in that case, which required a communication as well. So that for that reason, breach of fiduciary duty can satisfy, and does in this case satisfy, the statutory requirements for the TCPA to apply. Now, the second issue that's been raised is whether the request for injunctive relief is covered by the statute. It can constitute its own legal action independent of a cause of action. I don't want to spend too much time on that because it really only matters in one instance, and that's I think they would concede that that request is based on their claim for breach of fiduciary duty and trade secret misappropriation. And if those claims get dismissed, I don't think they would argue that the request for temporary injunctive relief also gets dismissed as well. What we're concerned with is if the court concludes that those two claims are covered by the TCPA, but maybe BGE meets its burden to prevent them from being dismissed. Our argument is that additionally, the BGE would have an obligation to support with clear and specific evidence the factors that we know are required for a request for a request for temporary injunctive relief or permanent injunctive relief, whether they've established a probable right to relief on the merits, whether there's an imminent harm, whether there's irreparable harm. Just like they'd have to show the element of damages to get that remedy on those causes of action, our argument is that that's the request for injunctive relief would also have to be supported.
So are there any cases that support that argument? Are you aware of any cases from any court?
The case that we cited the court to is that Better Business Bureau case out of Dallas. That's the only one that I'm aware of. I don't think any other courts have directly analyzed that in a case quite like this. There have been other cases that say, kind of what I said at the beginning, that if the claims that are underlying it get dismissed, so too does the request for temporary injunctive relief. But I don't think anybody's really been faced with a situation that we at least anticipate could happen, where the court says the claim survives and doesn't necessarily have to go into whether or not the elements have been supported for the request for the request for injunctive relief.
And how does the communication component that is discussed in the Abadatola case, and also in the first court's 2020 en banc Gascamp case, where does that intersect with the right of association in this analysis?
So the Reeves case is what said under Abadatola, the right of association was satisfied based on the allegations that they were addressing. I think the result would candidly be different under the en banc decision. I think that those two cases are in direct conflict, the Reeves case and the en banc decision in Gascamp. We, of course, relied very heavily on Gascamp when we were briefing this appeal. The panel decision was in our favor on pretty much all 4 points that it could be. And so the en banc changed that situation. But since that en banc decision came down, Reeves basically doubled down on Abadatola and said, no, we're going to go ahead and say that the competitive enterprise is the common interest. And when you're getting together to compete with other co-defendants, that is a communication. And so that's enough to satisfy the statute.
Does the fact that the statute was amended sort of in the interim between the original case that came out of the 14th and today, does that impact the analysis at all?
In our view, no. I think if there was an argument that this type of case is now excluded under the amended version of the statute, that almost gives credence to the argument that's been adopted by the courts of appeals that we've cited that says it is, until it's amended, this case is covered by the statute. If it weren't, there'd be no need to amend it. But I've not studied closely what the amended version is, because I know that one doesn't apply in this case. And under the old statute that's been interpreted in the cases that we've cited, primarily now Reeves is probably the most favorable case coming out of this court, is binding authority that under these circumstances, this type of communication for a common interest in a competitive business enterprise is covered by the statute under the right of association.
Given the statements that are in the BGE affidavits that proprietary material was downloaded while the appellants were still employed at BG&E and was taken to compete, while they were employed with another company, why are the statements that and other evidence in those affidavits not sufficient to show, to make BGE showing for breach of fiduciary duty?
For breach of fiduciary duty, if you're looking, yes, the statute applies, and then moving into step 2 on did they establish by clear and specific evidence their claim, if I understand the question correctly.
Mm-hmm.
Yep. I think it depends very much on actually scrutinizing the affidavits. I think that in the brief, they take a much broader view of what the affidavits say than what the affidavits say themselves. And just to give you an example, in their brief at page 43, they say that Mr. Kirsch, who's the expert who looked through the file listings, and his affidavit's the long one that has all the different charts with the files that he says were accessed. The brief says that he described the exact files and folders that were impermissibly copied, and then included the entire project folders that would have included these proprietary plat drawings. But if you go to the cited page in the record, which is CR 132, he lists file names. These are for months leading up to the departure. So while these BGE employees were working with BGE files on BGE work, there were many that were just merely accessed, not even necessarily downloaded or copied or forwarded. There's no information in the Kirsch affidavit about what the contents of any of those files are. It's just a file listing. And he expressly says, I'm not being asked to identify whether anything in these files is confidential or not. And in fact, he notes that some of them even appear personal, that these weren't even necessarily BGE's files to begin with. The same goes for the Youngblood affidavit that talks about the file plats that he reviewed that were publicly filed to compare them to see if there was maybe information that looked like could have been used. In the brief at page 45, it says that Youngblood describes in detail how Meta is exploiting BGE's plat drawings and customer information, and how Meta is continuing to use this information to BGE's detriment. That's not what the affidavit says. The affidavit says that there are these visual line types, line colors, these quote standards that are used in both plats that appear to be consistent. He doesn't even say it's impossible for those two things to have been replicated without using BGE's information. But it's certainly, if it's publicly viewable and visible, it stands to reason that it's not confidential or trade secret. And there's
Thank you. I think the initial time is up, but you'll have time for rebuttal.
Thank you, Your Honors.
Ms. Spear, we'll hear from the appellee.
Thank you. May it please the court, my name is Kendall Spear and I represent the appellee in this case, BGE Inc. In my time before the court, I'll explain why the trial court's denial of the TCA motion to dismiss should be affirmed for 3 reasons. First, because at the very minimum, the act does not apply to BGE's claim for breach of fiduciary duty or to its request for injunctive relief. Second, because even if the court finds that the act applies to any of BGE's claims, all of those claims are exempted under the act's commercial speech exemption. And third, even if the court finds the act applies, and even if the court finds that the commercial speech exemption does not apply, BGE met its burden under the second step of the analysis to establish by clear and specific evidence a prima facie case of each element of its claims. I just want to make just a couple factual clarifications that appellant's counsel touched on, and that is the allegation that BGE initiated this suit with unsupported claims. In its original petition, the affidavit from Noel Kirsch, the forensic expert who did the analysis of the appellant's BGE issued computers, his 15-page affidavit that chronicled all of the the information that was taken and all of the information that he found from their computers, that was attached to our original petition. When BG filed its first amended petition, it further supported the allegations in the original petition with the affidavit of Tracy Youngblood to provide further support for what BG's confidential information was and the specific steps that it takes to protect its confidential information and trade secrets. I also want to point to the fact that Appellant's counsel touched on briefly, and that is the authority that the defendants here relied on to support their motion to dismiss at the trial court level. The defendants relied almost exclusively on the First Court of Appeals decision in Gascamp to support their argument that the act applies. And as I'm sure the court's aware, the First Court of Appeals essentially reversed that entire analysis in its en banc decision from earlier this year to hold that the act did not apply. And as the appellants relied and conceded in their briefing, the facts in the Gascamp case are nearly identical to the facts that we have at issue here. And it also deals with the same exact causes of action of misappropriation of trade secrets, breach of fiduciary duty, and tortious interference. And so that just brings me to my first point, is that at the very minimum, where we're looking at the first step of the analysis, the act does not apply to BG's claim for breach of fiduciary duty. As is shown on the exhibits, Exhibit 1 and Exhibit 3 that we provided to the court, if we look at the definitions of the right of free speech and the right of association, as those rights are defined even under the former version of the act, a common component of those rights is a communication. In our argument as to why those rights are not implicated is because the breach of fiduciary duty claim is not dependent upon any particular communication. That claim rather is supported by the fact that these employees, while still employed for BGE, stole BGE's information and used it so that they could personally profit from it. And that is the fact that supports that claim. And the Dallas Court of Appeals recently addressed that issue in the Goldberg versus EMR case, in where the court held there that an allegation that the defendant is simply stealing information, that does not involve the making or submission of any statement, which is how the act defines the term communication. But even if the court finds that there were some implicit communications involved with regards to that claim, because of how we have alleged it, that the former employees who made up the entire land planning department, that they collectively colluded together to form this competing business, those implicit communications that support that claim still would not implicate the right of free speech or the right of association, especially in light of the Texas Supreme Court's recent decision in Creative Oil and Gas LLC, where the Texas Supreme Court provided further guidance as to the meaning of a matter of public concern. The right of free speech, as defined under the Act, is a communication concerning a matter of public concern, and the subpart of the definition of a matter of public concern that the defendants rely on here, and that the Texas Supreme Court clarified in Creative Oil and Gas, was where the communications involve a good product or service in the marketplace. And in Creative Oil and Gas, the Texas Supreme Court clarified that for the communications to implicate that right, they must have some relevance to the wider public audience of buyers and sellers. It cannot, the communications cannot just be relevant to the parties to a particular transaction. And if you consider whatever communications would have been involved to support our breach of fiduciary duty claim here, those communications would simply be communications that are pertinent to the private business endeavors of the former employees. And this court's recent decision in the Bowman versus Fortitude Consulting case confirms that also, which dealt with the business disparagement claims, where this court essentially held that that there was no implication to the wider public audience of buyers and sellers there, those communications were simply to the limited business audience of the plaintiff's customers and the plaintiff's tenants, and trying to disparage the plaintiff's relationship in those private settings. As to the right of association, that right also would not be implicated here with regards to the breach of fiduciary duty claim, because in reaching that decision, I would urge the court to follow the in the First Court of Appeals in Gascamp. And as we set forth in
under appellate principles, the 14th precedent is Reeves and Hyber and Abeticola. And so this panel would need to decide this case in accordance with our precedent, even though we're in this unique coterminous jurisdiction world with the First Court of Appeals. So given that we've got to decide this in accordance with our own precedent, how does your case get to a reverse on that?
Yes, Justice Frost. So in Reeves, I would note that Justice Zimmer dissented in that case and suggested that the facts of Reeves are somewhat distinguishable from the facts of Abeticola. And I would make the same argument that the facts of this case are also somewhat distinguishable from the facts in Abeticola. We have the split between the Texas Courts of Appeals in considering what kind of common interest can implicate the right of association. And in all of the cases that are on the right side of the chart that we've provided to the court in Exhibit 4, the cases that follow Gascamp and the Fort Worth Court of Appeals and the Dallas Court of Appeals, all of those courts are considering that there needs to be some community public component to the interest involved. And as Justice Zimmer noted in his dissent in the Reeves case, arguably in Abeticola, there was that community public involvement because there was a third party at issue in Abeticola, and the third party was not aware of the existence of a non-compete in that case. And so what's distinguishable from Reeves and this case is we don't have any third party involved with regards to the common interest. We simply have BG's entire land planning department that internally within BG got together and said, let's break off and start our own competing business. And so if we consider that distinction, I think that is one way that the court could find that the right of association is not implicated without having to overrule its decision in Abeticola. Now, I know the court's precedent in Reeves, it does apply to this case, but I would urge the court to consider the analysis from Justice Zimmer in his dissent, and as well as the analysis from all of the other sister courts of appeals that are considering this issue.
What about the commercial speech exemption? Does that apply?
Absolutely, Your Honor. And that's really the case dispositive issue here is the commercial speech exemption. And the conclusion that the exemption applies here is really compelled by this court's precedent in the McDaniel versus National Coin and Bullion case, in the Langley versus Inns Group case, in the Heber versus Pergeron Holdings case. All three of those cases involve the exact same fact scenario that we have here. We have former employees using confidential information from their former employer and then using that to operate in the same business to target the same kinds of customers. And in that situation, the Texas Courts of Appeals have pretty much become consistent, and in this court also, that this is the situation where the commercial speech exemption was intended to apply. And so as to my second point, we have met our burden to show that this is a situation where that exemption certainly applies. In their briefing, the appellants argued that the first and second elements could not be met as to the former employees because they were not They were not in the business of selling land planning services, and they were not engaged in the capacity of selling land planning services. But that argument has been squarely rejected by this court in the Heber versus Pergeron holding case, where this court held that it did not matter that the defendant was simply acting in his capacity as an employee for the benefit of the new employer to determine that that element had been met.
Let me ask you though, in the trial court, you raised the commercial speech exemption and argued it applied with respect to the tortious interference claim and the misappropriation of trade secrets claim. But you did not make that argument for the breach of fiduciary duty claim. Is that correct?
Well, no, Your Honor. As to our primary argument with regard to the breach of fiduciary duty claim was that the act was not implicated in the first instance. In our response to the motion to dismiss, though, I believe it's footnote 2 of our response, we provided that to the extent the court finds that the act applies to the breach of fiduciary duty claim, we would argue that the commercial speech exemption would apply to all of our claims, to the misappropriation of trade secrets and the tortious interference, as well as the breach of fiduciary duty claim.
If you have the burden on the commercial speech to lay out the case for the commercial speech exemption applying, and you don't raise it until the response, is that sufficient to preserve that?
Well, yes, Your Honor, because we wouldn't have, I mean, the only thing that had been filed before the response to the motion to dismiss was our pleading. And so it's not until the defendant, the movement, files the TCPA motion in the first instance, until that happens, our burden to raise the application of the exemption, I don't think, I guess let me say, I don't think every plaintiff, whenever they file any lawsuit, has to negate application of the TCPA before a movement files. Before a movement files their motion. And so I think we raised it appropriately in our response and sufficiently preserved that argument. As to the third and fourth elements of the exemption, I think that we also sufficiently met those elements. That the courts again are clear that where you have employees using the confidential information of their employer to target the same kinds of customers, that's the situation where the third and the fourth elements are met. I know that I'm running short on time, but I just briefly want to touch on the third point, that should the court get to the second step of the analysis in considering whether we establish our claims by clear and specific evidence, this we certainly did. Not only did we attach the 15-page affidavit from the forensic expert, but we've also attached the affidavit from Tracy Youngblood. And I also want to point, one point of clarification was that Tracy Youngblood in his affidavit testified that it would be nearly impossible to recreate this information from memory alone. And so the argument that he provided some evidence that it could simply be recreated from just a visual inspection. If the court goes back and looks at his affidavit on page 97 of the record, it's clear that we've established what we need to meet our burden under the act.
Do any of the legal presumptions that come into play in the jurisprudence governing misappropriation of trade secrets and related claims, do those come into play here in terms of what you presume if certain evidence was taken while in the employ of another?
I think they do, Your Honor. And if you go back to the Texas Supreme Court's decision in In re Lipsky, where the court was clear that that circumstantial evidence could be considered, and in that case was a defamation and a business disparagement case. But there the court also considered damages that could be presumed in defamation per se in different situations in that scenario. So certainly here where with regards to breaches of fiduciary duty, I think the court can make those presumptions that would otherwise apply in the law.
I believe your time is up.
Thank you.
Thank you. Rebuttal?
Thank you, Your Honor. I'm going to start first with the last point that counsel ended on, which is the Lipinski case, talking about the quantum of proof that's necessary to establish a prima facie case on each essential element. It was a defamation case. The court, though, said that, yes, you can consider circumstantial evidence, but general allegations that merely recite the elements of proof, that's not going to be enough. It's got to rise to a level that's more than just notice pleading, essentially. And it said it has to show the factual basis for the claim. And using defamation as the example, it said you'd have to show the facts of when the statement was made, where it was made, to whom it was made, what was said, and how it was damaging. And so if you look at the elements that you would need to prove in this case, starting first with a trade secret. What is the trade secret? Why is it confidential? When was it taken? What was done with it? There's no evidence of any of that in either of the affidavits that have been cited for tortious.
If I could interrupt you quickly, though, on that, but if the party clearly alleges facts that on all those issues, then is that not good enough?
It would be if it were more than just a general statement that claims trade secrets were misappropriated. Under Lipinski, that's not enough. There has to be some other factual detail about what the trade secret was, why it was confidential, when it was taken, who took it, and what for. So we think that the pleadings in this case don't rise that level, even if they could. And looking for another example at the contracts for tortious interference, you'd have to identify a specific contract that either existed or was likely to exist, and that Meta, by its own conduct, interfered with, and that BGE as a result lost. There's none of that in the record. Damages. BGE has alleged in a general notice pleading manner that they've suffered damages of in excess of $1 million. You're not going to find anything in the affidavit that gets anywhere close to saying that Meta actually caused damages to BGE. There's some dots there, but none of them are connected to the level of detail required by the Texas Supreme Court. Then I also wanted to touch on, I know that the Heber case was mentioned on the commercial speech exemption, but I want to take it back to Toth first, because I think that predates and applies more precisely to this case. And that related to the commercial speech exemption on the individual defendants. And we've argued that the individual defendants, that exemption can't apply because the requirement can't be met that the defendant be engaged in the actionable statement or conduct in their individual capacity as seller of goods and services. These individuals only ever sell on behalf of Meta for Meta's benefit. I think that's virtually undisputed in this case. Castleman says that requirement, that capacity requirement matters, and Toth confirms it. On page 155, the court said in that case, Toth was an independent contractor. He'd been hired by Sears, and he was selling or recommending a product to a customer in connection with some floor repairs. And the court said that claims based on that statement in that capacity could not be covered by the commercial speech exemption for the same reason we argue it can't in this case. And the court said the record does not establish that Toth made the challenge statement in his individual capacity as a seller of goods, and the only reason he was speaking to the customer was because Sears had engaged him to evaluate and potentially repair her floors.
So you're saying even if we were to conclude that the commercial speech exemption applied, you would nevertheless need to go through the main analysis with respect to all the individual defendants.
Exactly. I mean, we do still have our primary argument that for a separate reason, the commercial speech exemption doesn't apply to any of the claims in this case that we've briefed. But yes, Toth, if it stands for anything, it's that these individual defendants cannot be covered by that same exemption. And I'll give you a perfect example of why. So Catherine Parker, whose name I'm sure is not very familiar to any of you because it only appears maybe once or twice in the underlying record. She's one of the individual defendants that have been sued. Catherine Parker doesn't sell any goods or services on behalf of Catherine Parker. She only ever sells on behalf of Meta. And even if you were to assume that she did, what statement have you seen in this record, or what statement can BGE point to in which Catherine Parker communicated anything that could be covered by the commercial speech exemption? And if that's the case, it can't possibly apply to the individuals. Everything that's in the pleadings and in the affidavits is a communication that essentially Meta would have made. Meta's who is engaging in the business.
So how does that impact the right of association in the analysis?
So it's just a slightly different type of communication. The definition for right of association is just a communication made in furtherance of a common interest. And under Reeves, that's satisfied if they're getting together to talk about a potential competitive business enterprise. That was the same in Abeticola as well. I don't think that's been impacted any subsequent decisions. I understand Heber, at least as it relates to this capacity issue, is seemingly inconsistent with Toth. But Toth has not been overruled, and Heber notes in a couple different places that there was some briefing insufficiencies that I think maybe prevented the appellant from being able to prevail on this type of argument. If they had maybe been more thorough with that analysis, it would have been a different outcome. It doesn't necessarily overrule, and certainly can't overrule the decision in Toth. I see my time has expired.
Yes.
Thank you, Your Honor.
Thank you, counsel. Thank you both for your briefing in this case and for your helpful arguments today. This case is submitted and you are excused, and we are adjourned.
Thank you.
Thank you.